Case number 90198, State of Kansas v. Jonathan Carr.
Good morning, Your Honors. May it please the Court. I'm Sarah Ellen Johnson of the Capital Appellate Defender Office, appearing today on behalf of Jonathan Carr. And Your Honor, I would like to request 10 minutes for rebuttal, please.
10 minutes is granted.
Thank you. We are, of course, today on the companion case to the case that this Court has just heard, Jonathan Carr, the younger brother of Reginald Carr. So we are in the same posture, having received relief from this Court as to the death sentence, and then having gone up to the United States Supreme Court and now being back on remand from that court. And I would like to start my argument today roughly where it ended in the previous session, which is talking about the question of severance at penalty phase as a matter of state law. First of all, it's important to remember that this court found that it was error on the trial court's part not to sever these two cases from the get-go. As a matter of state law, then, these cases simply should have been severed, and that applies not just to the guilt phase, but to penalty phase. There's no mechanism in state law for rejoining two defendants at a penalty phase after they've been severed as they should have been here for a guilt phase. It's our position then that as a matter of state law, these two defendants should have had separate penalty trials, and that error is already established by this court's ruling in the original decision in this case.
Counsel, even if we agree with you on that point, could you address the questions that came from my colleagues toward the end of the last argument?
Absolutely.
About harmlessness and the language in the U.S. Supreme Court opinion?
Well,
I do understand the technical argument that we are not bound by an Eighth Amendment ruling when what we're looking at is state law and the statutory rule, but the logic of it.
Well, first I would point to an earlier quote from that Supreme Court decision, which is that they were not addressing procedural questions, that they weren't looking at the merits of what evidence should or should not have come in against one defendant versus the other. This is at Headnote 5 on page 644, that they were only focusing on whether this was an Eighth Amendment issue. They were not talking about the nitty-gritty details of the severance issue that this court would be looking at. And they were clear about that up front. If you read the transcript from that oral argument at the U.S. Supreme Court, it seemed also clear that the court wasn't quite aware about the severance issue at the guilt phase. They weren't even seemingly all aware that this court had found that that was error. I would suggest that suggests that there is a whole lot more to the severance issue than what the U.S. Supreme Court decided. They were looking at a very narrow portion of it under a very narrow portion of federal law. So
that didn't stop the court from, or at least the author of the opinion, from opining.
It did not, but I think it should stop this court from feeling that in any way should affect this court's consideration of the full case and the full question of prejudice due to the failure to sever. There's simply so much more to the issue than what was narrowly presented to the United States Supreme Court. And I think it's clear that the United States Supreme Court, as a general rule, doesn't get into prejudice analysis in the way that state courts do, because they are, as a body, looking at a different kind of take on an issue. They're not looking at the full spectrum of this case, as is clear. They only took review on two issues.
Why is it that complicated, though? Why isn't a prejudice analysis pretty straightforward? It's just, did what happened prejudice the defendant? And we have a couple different tests. We talk about a constitutional harmlessness test, state law harmlessness test. We're all familiar with those. And the Supreme Court of the United States pretty directly, it seems to me, said the joint sentencing proceeding was not unfair. And they said that with some pretty strong language, that it would require extravagant speculation, to conclude that it was unfair and that it's beyond reason to think that it's unfair. So I understand your point that they didn't have everything in front of them, et cetera, but why does that matter?
Well, that matters completely. How can their consideration of whether this was unfair?
So you're saying that they're wrong.
I'm saying they didn't have everything in front of them. I'm saying you're not bound by that by any stretch. And
Well, they were talking about the very specific issue that we are talking about now, which is a joint sentencing proceeding versus a separate sentencing proceeding.
they were talking about it within the confines of an Eighth Amendment
Right.
ruling.
And so
that's important to...
that gets to the question I asked in the last case, which is, what are we dealing with in state law that provides greater protections than the Eighth Amendment?
We're dealing with all of the factors that go into a state law consideration relating to a
For
severance.
severance. And what,
Right.
can you point me specifically to where in the law do we find something that either says or is clear that it protects an interest beyond and greater than the Eighth Amendment?
It's simply different factors. That this would be not a question of individualized sentencing, not an Eighth Amendment question. State law is, there's really no separate body of state law that relates directly only to sentencing. And that was the question before the U.S. Supreme Court, was only related to sentencing. Our position is that the finding that these trials should have been severed from the get-go carries over to sentencing.
So for purposes of this whole line of questioning, we're assuming error. We're just addressing the prejudice.
Correct. This court already found that it was error as a matter of state law for these trials to be joined. So the question is prejudice.
It seems to me to get around the Supreme Court's language, you either have to do one of two things. You have to say, well, that they were just wrong, or you have to say that what the U.S. Supreme Court said is not relevant because they were talking about prejudice to Eighth Amendment rights, and we are talking about prejudice to something different that
Correct.
exists in state law. And what I'm really trying to figure out is, what is that different thing?
I think it's actually, I mean, I want to answer yes to both of your questions, that they were just wrong and did not have adequate information to really make the assessment that they were making as to any sort of broader implication than the Eighth Amendment implication. But the different things that a state severance decision rests on are specifically whether a fair trial was denied and whether prejudice could have been avoided. And this court has already said that under our state analysis is correct, that we meet that test, that it should have been severed.
So what, I'm sorry, Justice Siegel, were you done with this
Well,
line,
just
or-
it does sound to me like we circle back to a due process question of a fair trial. At the end of the day,
Correct. Which is, I believe, separate prejudice from the Eighth Amendment analysis that the U.S. Supreme Court was considering.
So I think you were here for the earlier argument, and as I understood, the counsel who sat in your place for that case, when we were asking her about what kind of state law claim was being made, and then more particularly what standard of review for harmlessness would be applied, and she recited to us the state standard for harmlessness.
Correct.
Do you agree with that?
Yes.
Okay. But a minute ago, I understood you to say that this was a due process or a fair trial issue. So could you help me with my
Well,
confusion there?
That's the language that gets used when we talk about state severance. I'm not claiming that it necessarily in all cases rises to the level of a federal due process claim, but fair trial is the language that is used in this court's cases talking about analyzing severance.
So
as I-
not Fifth Amendment due process, but just general fair
That's-
trial.
I believe that's correct, yes.
That's what I was trying to nail down.
Correct.
And that would lead you then to agree with your professional colleague that it would be the state harmless error test to be applied,
Correct.
which is easier for the state to meet than the federal standard, is it not?
the state does not have to prove beyond a reasonable doubt that the error did not affect the outcome. That's correct. I would submit that in this case they can't meet any burden or to establish that this error wasn't prejudicial. If for no other reason, then we simply wouldn't have been joined at penalty phase at all if the trial court hadn't made the error at guilt phase. We simply should have had a separate jury all along, and so we necessarily would have had a separate jury considering sentencing phase.
Okay, refresh my recollection. Did the U.S. Supreme Court say that there just was no error, or that the error was harmless in failing to have two separate sentencing proceedings?
Specifically, they said that joint proceedings at penalty phase are permissible under the Eighth Amendment, and that they wouldn't forbid joinder. Then they get into this paragraph where they talk about whether it's improper to vacate a death sentence based on pure speculation of fundamental unfairness. That seems to be where they landed on. It's one of those cases where maybe they could have more explicitly stated whether they're finding it wasn't prejudicial or not error at all. It sort of, to me, was a little fuzzy in reading their.
What I'm getting at, I think it goes back to your colloquy with Justice Stegall. Assuming that the U.S. Supreme Court said that it was harmless error, they would have been applying a higher standard than we would be applying to your state law claim for harmlessness, correct?
Yes, but to a much more limited question, is my point.
That's what I wanted to get to.
Correct.
Okay.
That it's a higher standard of harmlessness, but to a much more limited question, and considering a much more limited scope of the case. And that's our position, is that it's simply a different harmlessness analysis entirely. And so
the fact that the state claim for the state test for harmlessness is lower than the federal, you're saying that despite what the U.S. Supreme Court said about a federal harmlessness, that really doesn't have any impact on what we're doing here because it's a separate set.
correct. And the scope of the issue is different, and the scope of the question to this court is different. That is our position. But I feel like this is naturally leading to sort of what I feel to be the crux of this case, which is the cumulative error question. It's been said.
Before you get
Yes.
to that, can you tell us maybe overview of why this would not meet the state harmless error test? What there was, what evidence came in that wouldn't have, or what was so prejudicial that we could not say that it was harmless under state law?
Well, first and foremost, Reginald's behavior in the courtroom throughout the trial was one of the biggest problems. He had to be restrained in restraints and declined the covering that was offered to him. And so he was visibly in restraints, and our position was that we were tied to him, as the state made clear in its closing argument. We share everything. The two defendants share everything. They share the same eye color. They share the same DNA. This is all part of their closing argument, this paragraph of all the things that they share. So when we share all these things, and Jonathan is sitting next to a man who can't even behave himself in court and has to be restrained, we share that too. In fact, the state actually did, in its closing argument, link Jonathan to Reginald's diagnosis of antisocial personality disorder. So we have all of this, it's this taint that permeated the entire trial of you're the same as your brother, and you get the same treatment as your brother, and you don't get anything separate. You're the same. That's our main position, certainly as far as what happened at penalty phase. Throughout the trial, Jonathan's attorneys were popping up and down, requesting, renewing their motion for severance. Throughout the trial, every time something was said, I think it's clear here today that we had a second prosecutor as well, someone pointing at Jonathan the whole time and saying, I wasn't even there, it was all him, and some mythical companion. So all of that is what we point to as far as what was the prejudice to Jonathan for not severing. And there was specific statement by the sister that we were not allowed to get into because Reginald had allegedly said something to the sister that we were not allowed to talk about. So these are the things that we point to.
What about the individualized and particularized jury instructions for each defendant? How does that factor into your statement that these brothers shared everything? The court was pretty careful to give individualized instructions, and that's what occurred here. That's what the U.S. Supreme Court pointed out that they gave. And what evidence is there that the jury didn't follow those instructions?
We're never going to have that kind of evidence is the problem, because we don't get to go into the jury room and hear what the jury is deliberating about. The best we can do is look at what evidence was admitted or was not admitted, look at what behavior occurred in the courtroom, and say, it's too much to ask of a jury to separate that out and not have how they view.
I mean, the trials happen all the time with outbursts and behavior and other kinds of things that are, and juries are instructed to either to ignore it or here's your job here, you're to focus on these instructions and these instructions alone. We don't speculate that they can't divorce themselves unless it's totally beyond the pale, but I don't see anything here that is. It's any different than what that happens in trials.
I would submit that perhaps we ask too much of juries and trust in them too much to be able to overcome these prejudices, that human nature perhaps is not as accommodating as we hope to believe that it can be. And in fact, there's research pointed into our supplemental brief about how juries don't follow instructions. Now, this is specifically relating to...
But is there any evidence of that here? I mean, you bring in some supplemental, you always do that, I suppose, to attack a jury verdict. But is there any evidence that occurred here, that the jury didn't follow the instructions?
We don't have any way to get that evidence. We're not...
I mean, there were no questions to the jury that they were, by the jury, that they were
No.
confused on certain things, or we don't have that here, do we?
No.
Okay.
The best we can do is say...
Is speculate is the best you can do, really.
And that's really what we do most of the time when we're looking at whether a jury verdict could be based on incorrect instructions or incorrect evidence or incorrect notions. I mean, we simply don't have any other mechanism to consider.
In fact, that's the whole harmless analysis. We speculate that the jury would have reached the same conclusion if there hadn't been error.
Correct.
We do that all the time.
And that's, the way that our system works. The times that we can get into attacking the reasoning behind a jury verdict is so limited that, we simply can't come back later and say, oh, well, we found out this one juror said this and that was really problematic. But I would like to move on to the question of cumulative error. Because
Before
yes,
you do that, can I ask about a couple of other issues?
certainly.
Jonathan Carr's counsel objected to the giving of the no adverse inference instruction at the
Correct.
penalty phase, correct? Which we would ordinarily regard as precluding him from pursuing it as error on appeal, and I know you haven't listed it as a special error.
That's correct.
You're not arguing that we should do so because of the death penalty rule, that we can take up errors that are not designated by a party?
I'm not going to contest that you absolutely can do that. That's the statute. You have that authority as a clear matter of law.
But ordinarily it'd be invited.
Correct.
Okay. The other thing I wanted to ask about was the testimony, or excuse me, the references by the prosecutor to uncharged conduct by
Correct.
Jonathan when cross-examining mitigation witnesses. It's my understanding that there were only there were maybe only one objection to any of that evidence, as along the lines that the state needed to be able to prove what it was alluding to. Is that right?
That's correct.
Okay, and that was overruled. We made some reference to that in our earlier
Yes.
decision. Ordinarily, when we have that kind of a problem, with a question by a prosecutor. This court is unable to do anything about it unless the state has been put to proof, basically by an objection by the defendant.
Correct.
So how does that work with the rule I just made reference to in death penalty cases? I mean, it seems to me that there's a record lack there that has to be laid at the feet of the defense.
One thing I would point out is that this trial occurred in 2002, and that is, I do believe, before this court issued State v. King, making it completely clear about the need to object to questions that would be considered prosecutorial error now. So there is that fact matter of, was the defense on notice that they had to object to pure prosecutorial error when at the time of that trial perhaps there was room to raise those issues on direct appeal without there being an objection. And of course the other point I would point to is the statute still gives this court authority to consider errors whether they were objected to at the trial court.
I understand, that's what I'm getting at. I know we have that authority, but how do we do it when we don't have a record made of whether the state had a good faith basis for the questions? And the reason we don't have a record for how the state had a good faith basis is the defendant failed to object.
And I understand that that's
It's a conundrum.
That doesn't change the fact that the state was bringing in evidence that it didn't offer any fact basis for it. And in fact, I mean, one of our greater problems was when on closing argument they were talking about all of this stuff that there was no proof of. Simply asking a question of a witness, did you know about this or have you heard about that, is not evidence that actually occurred, is our position. So I would submit that that is still something that this court can consider within the cumulative error, certainly.
Counsel, a number of times you've wanted to get to the cumulative error argument, and I'll give you a chance to get to that. But before you do, what do you believe is our test for harmlessness for that?
Well, as this court said most recently in both State v. Kleypas and State v. Cheever, very recent cases, that the question is not what effect the error might generally be expected to have upon a reasonable juror, but rather what effect it had upon the actual sentencing determination in the case on review.
And what I'm trying to find out, I acknowledge that from Cheever and Kleypas, but are you making a state law claim or a federal claim when you're making your cumulative error argument?
We, I believe, originally raised it sort of both. We always cite to the due process requirement of a, fair trial, a constitutionally fair trial. This is also a state law issue, I think. So it's sort of one of those issues that can be argued both ways. I think under a state harmless error test, this case passes muster, and this court should find that cumulative error tainted this trial so severely that the sentence cannot be affirmed.
Okay, so I want to make sure I'm not putting words in your mouth. Are you saying that you are making purely a state law claim of cumulative error, or you're saying also a federal claim?
I do believe in the original briefs we raised it as a federal claim and it's always a state claim as well.
And so even though this case has gone up to the Supreme Court and back, you're still relying on your original brief to make both those arguments. Is that right?
Correct. Our original briefs as to any of the issues that are still outstanding still stands. And the supplemental brief is simply updating and supplementing. But that issue still stands and still has not been ruled on by this court. And so we certainly submit our original briefs are still valid and raising those issues.
Very well. We keep interrupting with our pesky questions. Would you like about 2 minutes to get to your cumulative error argument?
I would, Your Honor. I appreciate that. Thank you. The question has come up several times. Of course, we know that a defendant is not entitled to a perfect trial. I think the question that necessarily follows is, how imperfect must a trial be before a reviewing court can say we cannot affirm a death sentence from these proceedings. At guilt phase, this court found 8 separate errors, 8, including major errors that 3 members of this court would have found each separately merited reversal of the convictions. We must remember that one of those errors was the denial of a peremptory strike to the person who turned out to be the foreperson of the jury. How can that error not have affected the deliberations of the jury at sentence, where one vote makes the difference, and we already know there's one person on that jury who should not have been there? That's necessarily affecting the outcome of the verdict at penalty phase. The sheer quantity of error and the way that they interlocked in this case, this failure to sever, the failures to instruct, the overcharging that occurred at the guilt phase, all of these things combined with the separate errors that occurred at penalty phase, some of which this court has previously already alluded to, the denial of surrebuttal evidence. Some of the prosecutorial error claims have already been alluded to, the confrontation clause issues that occurred at penalty phase. Looking at the totality of the errors in this case, I don't think there's any way that a reasonable court can say that those errors had no effect on this verdict. I would ask this court to find that the great weight of cumulative error did in fact poison this trial, and that Jonathan Carr is entitled to a new sentencing trial.
And you prefaced that argument on how imperfect in a death penalty case.
That's correct.
How much imperfection can we tolerate in a death penalty case? Are you then saying that that is because we have the heightened scrutiny / heightened reliability requirement?
That is absolutely a factor that this court cannot overlook when considering, especially we're considering right now, the effect of cumulative error on the sentencing phase in a death penalty trial.
And the reason for that heightened reliability requirement is that the death penalty, when executed, is absolute, but the standard by which we get there is just beyond a reasonable doubt.
That's correct.
Any further questions? Thank you, counsel.
Thank you.
May it please the court. Since we've had an extended discussion about some of the joint issues in this case, I'd like to just jump in and talk about some of the issues that counsel just talked about and address Justice Stiegel's question in part regarding the severance issue and why perhaps the logic of the United States Supreme Court maybe doesn't control this issue. The state is unaware of any state law basis that would require a different result than reached by the U.S. Supreme Court. In the briefs, counsel is asking that this court make a ruling that the Kansas Constitution would provide greater protection. And it's something that this court has been hesitant and reluctant to do. And in fact, in the Scott decision, this court found that there was no difference between the two, and that notice that traditionally this court has considered the Eighth Amendment equal to Section 9 of the Kansas Constitution. The statutory basis, the state sees no reason in that statutory basis to reach a ruling under state law that would require reversal in this case. I would note that, and this court is aware, Justice Breyer, I think you mentioned it was 6-1 on the severance issue before, and I would note that one difference we have here, and I don't know if the underlying question from this court concerned whether you could reconsider your decision on that. I know that in some of your more recent capital cases, there was a question as to how rooted in you were because of law of the case, for instance, on an issue. I would note that Justice Stiegel is new to this panel. He wasn't part of that 6-1 decision. And to the extent that that makes any difference, it doesn't really change my argument. And I would ask, to the extent this court is willing to do so, that you evaluate that 6-1 decision, because I do think that that decision on state
Counsel,
law.
can I interrupt you there? I need to make certain I understand what you just said. You're asking this court to revisit decisions made that impacted the guilt phase? Is that what I heard you just argue?
No. I'm asking you, because we're taking up the penalty phase, the notion is that the state law, this court has
Well,
already found.
what part of the 6-1 decision would we reconsider? Because as I understood, at least, that referred to the ruling that severance in the guilt phase was error as a question of state law.
Correct, but
And did I mishear you? Didn't you just say we should reconsider that?
what I was referring to, because there was a question from Justice Breyer earlier, my answer to that question was we should reconsider that decision in light of the penalty phase alone. That I think that this court can do that and not just be stuck with what it ruled on with the guilt phase. I'm not asking you to reconsider the decision on the guilt phase. I'm asking you to consider the penalty phase separate. As a separate question.
Then answer the query I heard from Ms. Johnson. How do you rejoin? As a practical matter, if it should have been severed at the guilt phase, how could it ever be rejoined for sentencing?
Well, first of all, I don't think that's the question we're asking, and I don't think that's what we're suggesting that they rejoin. Whether it could actually be rejoined is not the question. The
Well,
question
what we're
is,
talking about is the determination that it should have been severed in the beginning. Does that carry through? Is that a decision that establishes that there was error in the penalty phase because it should have been done before? And I'm asking, how could it not be an error in that phase if it was an error before it got there, when there's no way to get there without going through the first phase?
I mean, this is probably a pure academic argument, Your Honor. I don't think that's the right question to ask as how were we going to rejoin. The question is the fact that they were separate, is that a violation of state law as to the penalty proceeding only? I mean, if the answer is that that they had a right to, or that it was required to be severed as a matter of state law, then that answers the question without regard to whether you could have ever joined them in the first place, or that they had to be joined in the first place. I guess.
You're just asking us to disregard what the ruling was in the guilt phase, take it, put it in a box, and just concentrate on whether there was a state law error in the penalty phase.
Right,
Period.
very similar to what happened with the U.S. Supreme Court. The question before the U.S. Supreme Court was it error to have a joined penalty phase jury? The question during the guilt phase, it was during the penalty phase, and that's why I'm asking this court to revisit that, because I do think that this court's decision on that was colored by the notion that there was an Eighth Amendment violation, and I think if this court revisits that issue,
You think our guilt phase ruling was colored by the penalty phase?
No, I think your decision regarding severance being an error in the penalty phase.
That was an Eighth Amendment decision.
Right.
And that's what got reversed.
Right.
Yeah.
And-
I think I understand you. You're saying don't be holistic, and your opponent's saying please be holistic, and it's
Right.
understandable why you would each take those positions.
And the reason I bring that up is I'm getting the notion that it's a foregone conclusion that this court has already found or will find that there's a
State law violation.
state law violation as to the
Understand what
penalty
you're saying.
phase, and I'm
Yeah.
to the extent
We
this
have
court is-
asked you several times to assume that and talk about
Right.
that.
And that's why I
Talk
bring
about
that up.
homelessness. Can I ask you a couple of questions that are very specific to Jonathan Carr and his case?
Sure.
Or I should say, very specific to him. Obviously, it was a joint trial. I'm trying to understand what the prosecutor was trying to accomplish when asking the questions of the mitigation witnesses that included information about uncharged conduct. Was that directed to proving the existence of the aggravators? And if so, I mean, why was that information relevant? Was it directed to proving aggravators, and if so, which ones? Was it directed to rebutting mitigators, and if so, what mitigators? I'm just trying to understand what was going on there, other than what has been alleged, which is that it was inflammatory and malicious, in bad faith, etc.
Right. Well, I think part of the notion that's being proposed, at least in the briefs, is that that evidence was a non-statutory aggravating factor. And again, I think that that issue would be controlled by the notion that there were jury instructions concerning what the aggravating factors were. And the jury should be presumed to have followed those. The second part of that would be...
I'm asking kind of from the other end of the question. What was going on? If that wasn't we can have that discussion in a minute. Rather than responding to what the accusation is, I'd like to understand what the point was.
Well, the point would be, if you're proposing, in the case of Jonathan Carr, when he was proposing witnesses like Jesse Harris or the Culvers, to show that he was a good character person, and then the question became, were you aware of these other things, and would that change your mind about that?
Pure impeachment of good character evidence for those witnesses.
Correct, and going to mitigation, and not. I think clearly, especially if you look at the arguments being made, I don't think that was being proposed as something to go on the aggravating side of things. It went to whether the jury should exercise mercy on Jonathan Carr. And Justice Beyer, I know you were speaking about the general objection about proving it up, and my commentary to that would be, this court noted in its first opinion, it said, in reference to this prove it up, that there's an objection and that it was overruled. This court noted this objection probably should have been sustained by Judge Clark, C. McCaslin. The state would disagree with that for the reason, as I alluded to at the end of the first argument, is in the context of when this case occurred back in 2001, the rules of evidence that McCaslin is predicated on did not apply to the proceeding at hand. We had 2146-24 that allowed the state to provide evidence, and as long as the defendant had ability to rebut that. So with regard to statements that were being made, we did not have an evidentiary mandate to prove up anything. The defendant had the ability to rebut that. He didn't say that the evidence or the question regarding his past conduct wasn't true, or that the state, going to your comment about the objection, I mean, he didn't say these things didn't happen, that's ridiculous, prove it up. As far as that is concerned, he just said prove it up. So I don't think there's an evidentiary basis for this court to conclude that there was any error in that stage. Now, what we obviously know at this point... Are
you talking just generally about the more relaxed evidentiary standard? Is that
yes, Your Honor.
Okay, I just want to make sure I'm understanding what you're saying to me, that the more relaxed evidentiary standard changes the McCaslin waterfront.
Right, and I think if I recall in the briefs, the argument was at 6456 and maybe 6460, which would be the hearsay statute, somehow put some burden on us. And then if you look at the McCaslin case about proving up something you're attempting to impeach with.
I don't want to delay you long with this question because it's more theoretical, and I want you to be able to get down to brass tacks. But there must be some outer limit, right? I mean, the state can't just walk in and say anything, and then it's, as long as the defendant can say that's not true, the state can say anything? Surely not. You don't mean that, right?
Well, I suppose it would depend on the question. I think there would be a boundary.
Has to be
Obviously,
some
if there's a
parameters.
claim
Okay.
of prosecutorial misconduct based on something that is absolutely false, I think that would be a separate question than what you have before you is, was there an evidentiary basis to force us to prove that up? And if you have the relaxed evidentiary standard, then I don't think there's any basis to say that we were required to prove it up. Not with regard to Jonathan's past conduct. And the same would apply, as I alluded to at the end of the first argument, is with regard to what the other experts said. So the notion that that comment or that objection is a good objection based upon Kansas evidentiary rules, that is false. At the time, we were able to do that. Nothing stopped Jonathan's attorney, or Reginald's attorney for that matter, from calling those people to the witness stand to rebut what was being proposed.
Which makes it non-hearsay. Frankly, if they're sitting in the courtroom, it's not hearsay to start with, and I mean, it's not a confrontation problem if they're sitting right there and can be called. But anyway, I
Right.
won't. Again,
Right.
we don't need a long delay on that.
Right,
point.
but that goes to my argument about perspective is I think the natural inclination at this point is to somehow say, Judge Clark was way out of line by allowing this to happen. Well, the rulings that were made were in line with what the law was at the time. What changed was a Crawford decision that came down the road somehow. And now we're confronting the issue of confrontation and dealing with that issue. So, I'm not saying that wipes the slate clean and we don't have to deal with confrontation because Judge Clark wasn't faced with that issue. I'm just saying, I think we tend to be critical of what has happened in a trial, but I think you have to look at why it happened. And in this case, there was no error by the judge's ruling. We only know after the fact, because of Crawford, that we have an issue before us.
I understand.
I would note, as far as the cumulative error, I think that's the other thing that was addressed by counsel. She mentioned Reginald being in handcuffs. That was a matter that the U.S. Supreme Court addressed in part, and whether that's binding on this court or not, it really makes no difference to me. I think the reasoning by the U.S. Supreme Court that it's incredible to think that Reginald being in handcuffs somehow prejudiced Jonathan. The U.S. Supreme Court's take on it was it actually makes Jonathan look better because he's the one not in handcuffs. I think it's a small part of the case, but when you're talking about harmless error or cumulative error, I think it bears in mind that I think that is not something that this court should consider when it's discussing cumulative error. One thing that it hasn't been stated directly, but I think the proposition being proposed by counsel is that because the mercy question is something that's subjective, it would be very difficult for this court to go back and get into the minds of the jurors, and determine whether an error could be harmless. Now, in this case, we're talking about a slate of errors, but if taking to its logical conclusion, what I hear counsel saying is that if there is any error, it would be impossible for this court to put itself in the position of the jury and make the difficult decision regarding mercy, because mercy can turn on a dime. The state would ask this court to consider that when it's making its decision on whether it can weigh the errors in this case, because I do think it is the quality of the error, not the quantity, that drives this decision-making process. I also believe, and this court has indicated that the overwhelming nature of evidence is not controlling and its impact is limited. Honestly, I don't understand that statement, except that I think the overwhelming evidence is important. The U.S. Supreme Court has indicated itself the overwhelming evidence is important. If this court is to mean that the overwhelming evidence isn't important as far as the guilt phase is concerned, and maybe that it's only important to the strength of the aggravating circumstances, because at this stage we're worried about do the aggravating circumstances outweigh the mitigating circumstances. But I do think that the power of the evidence has to be included here, because otherwise, why would residual doubt be an issue? If the strength of the evidence isn't important, why is residual doubt important for the defendant? So I do think that the overwhelming nature of the evidence in this case, as this court has recognized in its original opinion, as the U.S. Supreme Court recognized, I think that any error, individually or collectively, that is addressed by this court pales in comparison to the strength of the evidence, and none of those things would have quantitatively affected the verdict in this case. What we can't forget is that the jury in this case was a death-qualified jury, which indicated that it could impose the death penalty if required to do so. The defense position, I think, undermines that, because it doesn't take that into consideration, in that it doesn't consider that in this case the jurors sat through 2 months of trial indicating these horrendous crimes, which everybody can agree on were horrendous crimes, and that somehow they're going to put that aside and they're going to look at this mercy picture without considering what the strength of the evidence was, at least with regard to the aggravating factors. And I would submit...
I'm not
Yes, Your Honor.
really following that. Are you saying if you get a death-qualified jury that says they're ready, willing, and able to impose the death penalty, that mercy's off the table?
No, I'm not arguing that at all. I'm just saying that they're inclined to impose the penalty, as opposed to somebody who is not inclined to impose the penalty and would grasp onto mercy as something that they can rely on not to impose the death penalty. And I'm not saying it was automatic. I'm saying what made it very difficult in this case is...
You're just saying the death-qualified jury would not be looking for an excuse not to impose it. Is that what you're saying?
Not without regard to the evidence. But yes, I mean, they're not looking for a way out. They're just looking at the evidence from a blank slate as far as what the penalty is in front of them. They're not trying to avoid anything. And I say that because what we have is, when we have the defendants arguing against or arguing cumulative error, they're obviously coming from a standpoint that they don't believe that the death penalty is appropriate.
Counsel, I had a question about this discussion on what you've characterized as overwhelming evidence.
Yes, Your Honor.
And I just want to make sure I'm understanding where your argument is. Are you willing to concede that there was any error in this trial?
Yes, there was error in the trial.
And any error in the penalty phase?
That's a tougher question. Potentially, yes.
Okay. So if you'll bear with me, if there was this amount of error throughout all the proceedings, you're saying that the evidence is so overwhelming that that error is harmless, correct?
Yes, in part, and I do have something else to go with that, which I've not gotten to yet.
All right. My next point is, are you saying that it does not matter how much error there would be committed in these proceedings as long as the evidence was overwhelming?
No, and I think I agreed to that in the first argument, 4 years ago. I'm not saying that at all, because I do think there becomes a point where it wouldn't be harmless. But I do think that, again, I don't think it's a quantitative or quantitative issue. I think it's the quality of whatever the error is. If you had 10 errors that just couldn't possibly have any bearing on it, then obviously I don't think that those things can add up to cumulative error. almost from the 0 plus 0 plus 0 can't be 1 type of argument. I don't think we reached that level in this case, and I don't think I did a very good job in the first argument talking about this. But I'm being asked about a general question, and I think when you look at each error in this case, I don't think that it adds up, because I don't think there was error that affected it. And for instance, I alluded to Dr. Pay and Dr. Preston. And with regard to Jonathan, he also had Dr. Cunningham on his side of things. The arguments that were, the errors that were being made with regard to, let's say for Dr. Pay to be able to, or Preston to be able to come back on SIR rebuttal. Much has been made about that and whether Judge Clark made the right decision. This court has found unanimously that error was an abuse of his discretion not to allow it. But I think when you're looking at that error, you don't only look at what he was prevented from doing, but you also look at the other parts of the trial that allowed him to do something else, the defendant to do something else, and how he would combat that. Nothing stopped the defendant in this case from continuing to argue his case and the strength of his evidence. It wasn't as if the jury was something was completely withheld from the jury and they couldn't consider it.
There was something completely withheld on the SIR rebuttal issue. I mean, SIR rebuttal issue is probably water under the bridge at this point, other than for cumulative discussion, but there was something withheld. The defense didn't get an opportunity to have its witness respond to the accusation that he had phonied up his testimony and the support for it. And that was not permitted. You don't think that was something that might have been important?
I was speaking more probably generally. I mean, you are right about that.
Well, I think your criticism has been that we're focused too generally and we need to be talking about specifics, and that specific seems fairly important.
Well, I'm looking at the impact of the error too. The notion that's
Am I correct, first of all, though? That was something that was omitted from the trial as a result of the ruling on SIR rebuttal.
Correct. That was what was proposed that he would testify about.
Thank you.
What I'm saying is this. This isn't a situation where the defendant was left with no ammo to argue his case on mitigation. Regardless of whether one expert disagreed with the other expert, and that's, again, I think Judge Clark was within his bounds to do that. However, just assuming that it continues to be error, the defendant had the ammo to do it. Whether the expert comes in and says, no, there was, this was misinterpreted, it still left the defendant with the ability to come in, especially with this testimony from Dr. Cunningham about the effect of brain damage on his behavior and how that impacted his life. So it wasn't as if the jury couldn't see that and make a determination based on that. If they were inclined to grant mercy, I would submit to this court it didn't turn on whether the Dr. Preston came back in and said, no, I wasn't lying about this. This is what I meant. Because what was clear to the jury from Dr. Cunningham and Dr. Preston was something was going on there, and it wasn't Dr. Preston's credibility alone that was an issue. There was other testimony there that the defendant could build on to make his case, and that's why I say I don't think it was impacting when you look at it in a general sense as far as was there reversible error here because Dr. Preston wasn't permitted to come back in. I would submit that it's the answer to the question is no, and we know that because of the other evidence presented in the case.
I understand. You're
Does that answer your question?
Sure. Yeah, that's fine.
Okay. As far as the remainder of the cumulative error arguments, excuse me. I do think, again, the non-statutory aggravating factor, this court does have to overlook that part. The argument that the defendant didn't get individualized sentencing. I just don't think that that suggestion, if it's not being made explicitly, but the suggestion is that somehow this joint trial infected that part of it, and I just don't think there's any basis to make that argument. I think Justice Rosen was alluding to that, is we don't have any proof of any of that, and I would ask this court to follow that line of logic. As far as the confrontation clause issue, I would ask this court to make a finding that the confrontation clause does not apply. As noted in my supplemental brief, I do believe that this court is not in a position to find that as a matter of federal law that the confrontation clause applies at the penalty phase. I think that's a decision left up to the U.S. Supreme Court, and it's something that the U.S. Supreme Court in the Bossie decision indicated when they found that a lower Oklahoma court made an error in trying to expand the law. It's something that has a basis in the law, and I would ask this court to make that finding. On that issue as well, as far as the police reports are concerned and the confrontation on those, I would note that any complaint about the quality of the information that's being proposed for Jonathan and his prior crimes that weren't proved up, so to speak, that evidence pales in comparison to what he did in this case, and he never made much of a fight to say that he wasn't involved. And just as with Reginald, his attorney didn't make any excuses during the opening and closing in the penalty phase. He owned it. He said, my guy did it. In other words, we just ask you to find some reason to grant him mercy. If that is the case, I don't know how any evidence regarding the police reports or unproven conduct had any bearing on the jury's decision. I don't see how that could possibly sway a jury to say that man deserves to die. It pales in comparison to what happened in this case. For those reasons, I would ask this court to make a finding that cumulative error does not require reversal in this case, no matter what standard is applied.
Does that conclude your presentation?
It does, Your Honor.
Do we have any questions?
Yeah, I do. I think you referred to some discussions we had previously about the Constitution is not restricted to people that are not guilty. That even we've agreed that even guilty people are entitled to a fair trial under the Due Process Clause.
Absolutely, I firmly believe that.
And I hear you today say that there is a place a point at which qualitatively significant error simply can't be overcome by overwhelming evidence as a matter of constitutional law. Am I overstating what you're saying? That even if we believe the evidence is overwhelming as to guilt, if the errors are so qualitatively significant that we couldn't say that it was a fair trial, that he gets overs. Is that what you're saying? That's what I was hearing, and I want to give you a chance to say, no, Justice Johnson, that's not what I'm saying.
No, I do think there's a point that becomes an issue. I don't think that point was reached here, but I don't.
Well, I understand that, but I'm just saying, does that point exist in the law?
I think so. I think it'd be foolish to say otherwise. But I would also say, I don't think I said it when Justice Beyer was asking me about it, but could have been Justice Nessa. But if there's prosecutorial misconduct or something of that nature, if you raise that, if there's some kind of malice in what has occurred, I think that makes it more difficult to do that. So I think that's would be part of the analysis and looking for that kind of error. I think it's more of the exception and not the rule that harmless error couldn't apply to a case.
In spite of the overwhelming nature of the evidence.
Right, I think that would control.
Because that seems to me it's almost the state's position throughout this has been, evidence is so overwhelming, it's only anything short of structural error wouldn't be a means of reversal, is
Absolutely, because I think the
In this case, that's kind of your position. It's so overwhelming here that anything short of a structural error would not result in a reversal.
right. The unspoken thing is if we tried this case again, 100 times, are we going to reach the same result? And I think if you can answer that question, yes, I think that it does make a difference, and I do think the overwhelming nature of the evidence does control in many cases.
Any other questions? Thank you, counsel.
Thank you.
You've reserved 10 minutes for rebuttal.
What I just heard my opposing counsel suggest is that Jonathan Carr doesn't get a fair trial. That because this case is widely considered the worst of the worst in this particular state and is perhaps the best known case, and any juror who ever heard this case would find the same way, then it doesn't really matter, short of structural error, how bad the trial was. And that can't be right. We have a duty to make sure that death sentences are imposed properly. We have heightened reliability, heightened scrutiny that needs to go into these cases before this state uses its awesome power to execute someone. Jonathan Carr is entitled to a fair trial, and he did not get one. It really can't matter that he's a Carr brother. It has to matter how the process went. We have a process for establishing when an individual is to be found guilty and when an individual is to be sentenced to death. And when the process breaks down as many times and in as many ways as it did here, we cannot say that that verdict is reliable. It's our position that the weight of error in this case is so great that this court has no choice but to reverse the death sentence.
Do we have any, I'm sorry, does that conclude the
That
presentation?
concludes my presentation.
Very well. Do we have any questions? I see none. Thank you, counsel.
Thank you.
We thank both of you for your arguments this morning, and the court will take this matter under advisement. That concludes